Regulating Act 1773 is a significant British decided to regulate East India Company and demarcated the political and administrative function of the company. Laid the foundation for the central administration, and Governor of Bengal was designated Governor General of Bengal. Governor of Bombay Madras became subordinate, and the Executive Council of 4 members was formed, and officers were prohibited from private trade. And first Governor General Warren Hastings and the Supreme Court established Calcutta. So demarcation of political and administration functions, and the British decided to regulate the East India Company. Then Pitt's India Act was came, and it was demarcated the political commercial function of the company, and the commercial affairs to be managed by the court of director, political affairs to be managed by the newly board of control, and the board of control can supervise the operations, government and revenue. British government got complete control over the company affairs. Now next one, 1853 Act. So this act was the separate the governor was appointed for the Bengal, extended the company rule to possess Indian territory, separated the legislation from the executive functions, and open competition was introduced in the recruitment of the civil services. Macaulay Committee was appointed in 1854. Number of the courts of directors were reduced by 24 to 18. Legislation became a separate entity, like Central Legislative Council was formed. It functions the mini parliament in making the laws. So this is the 6 legislative members were there. Local representation was first legislature, and now meeting was there, and 2 members appointed by the British. So this Madras, Bombay, Bengal and Agra. This was this all. Next one is Government of India Act 1858. It's a East India Company was abolished now. Court of Director and the Board of Control were abolished, and the Governor General India was resigned to Viceroy of India. Office of the Secretary of the States was formed. Secretary was the member of the British. A 15-member council was formed as an advisory body with the Secretary of the States, also called the Act of the Good Government in the India. So it's a 15-member council was formed at the advisory body, an Act of the Good Governance of India. First Viceroy of India was the Lord Canning, and the direct representation for the British Crown. Lord Canning was the first Viceroy, and the Act of Good Governance. A 15-member council was formed. Office of Secretary of the State was formed. Governor General, known now Viceroy of India, and the Court of Director and Board of Director was abolished now. Next one, Council India Act. Legislative power of the Bombay Madras were restored. Viceroy can appoint Indian as a non-official number of his office. New Legislative Council was established at the Bengal, it's 1862, and the New Western Frontier 1866, Punjab 1893. Viceroy was empowered to make the rules and orders. Viceroy can issue ordinance during the emergency. No need for the supports from the Legislative Council, valid for the 6 months. Now Lord Canning nominated 3 Indians to his Legislative Council, and the portfolio system was important. Lord Canning was nominated 3 Indian in the Legislative Council: Raja of Benares, Sir Dinkar Rao, Maharaja of Patiala. Portfolio system got the importance in this act. Next one is the Indian Council Act. So this increased the number of the member non-official in the council. Legislative member can discuss budget question, and the nomination system of the non-official member. Viceroy can be appoint a non-official member in the Central Legislative Council. Governor can appoint non-official member for the provincial legislature. Next is Council of India Act 1909. Central Legislative Council was expanded from 16 to 60 members. Members' quote in Provincial Assembly was not constant. Members in Council were empowered to ask the supplementary question and move resolution to the budget. Provincial Legislative Council was allowed to have non-official majority. Indians were admitted in Executive Council of Viceroy and Governor. System of the communal representation was introduced, and the separate electoral system was there now for introduced for the Minto also. So the Muslim can be only be the Muslim. Also the provided local bodies and Jamidar become the father of the communal representation. System of communal representation was introduced, and this act is also called the Morley Minto reforms, or Lord Morley was the secretary. Minto was the Viceroy of the India. Satyendranath Prasad Sinha was the first Indian to join the Viceroy Executive Council and appointed as a law member. Next is Gardner of India Act 1919. It's also known Montesquieu Chelmsford Reform. Montesquieu was the Secretary Chelmsford of the Viceroy of India. British declares the Act of Introduction of Responsible Government in India. Provincial subject was divided reserve subject. With this was appointed by the governor along with the Executive Council, not responsible to the Legislative Council, and the transfer subject was administered by the governor with the aid of the ministry, and the ministry are responsible to the Legislative Council, and the central and provincial legislature were authorized to make law on their respective. The system is popularly known the diarchy. So budget or provincial budget were separated from the central budget. Provincial legislatures were empowered to enact this budget, and provision for establishment of Public Service Commission, High Commissioner for India, transfer subject functional Secretary of the State to Commissioner. Central Legislative Council was replaced by bicameral legislation, and the direct election was introduced for the election a member of the legislative. Franchise was linked to the affluent people on the basis of property, tax, and education. Separate electorate introduced Sikh, Anglo-Indian, and the Indian Christian and the European. Transfer some functions in the Secretary of the States to be commissions, and the upper house of the Council of States, lower house of the Assembly is there. Next is the commissions. Commission was a statutory commission, 7-member consultant to report the impact of new constitution on India. Chairman Sir Simon, and the 1930. So abolition of diarchy, continuation communal electorate, establishment of federal Indian British Indian province, responsible government. All member in the commissioner was British, so the commission was appointed 2 years before the schedule. Communal award was the scheme of representation of the minority announced by the Ramsay MacDonald PM, and the separate electorate was extended to scheduled caste. Gandhiji fast led to the Pune Pact, and the Hindu too has joined this, and reserve subjects was there. Next is feature of 1935. So this is the bicameral, 6 bicameral legislation introduced: Bengal, Bombay, Madras, Assamese, Bihar, and United States. Extended the separate electorate to the schedule caste, laborer, and the women. 10 schedule and 321 sections were there. Provincial for the established RBI. Abolished the Council of India. Provision for establishment of Federal Public Service and Provincial Public Service, Joint Public Commission, and the Federal list, provincial list, and the concurrent list was there. Introduced responsible government for this government of should be the according to this, and came to 1937. Provision for the all India federations. Diarchy was abolished to add the province for the centre. Provision of the partition of India. British adopted its title Emperor of India. Abolished the office of the Viceroy, office of the Secretary of the State. Governor General was given power to assent to the veto the bill. Discontinued the appointment of the member for civil service. Ended the British rule in India, and the India became the sovereign states. Provision for the Government of India by the Government of India Act 1935, and granted freedom to the princely state to either joint remain independent. Empowered the Constituent Assembly as a sovereign body to frame adopt their. Next one is first proposed M.N. Roy. Indian National Congress demarcated the Constitution 1935. Demand was accepted in the principle of 1940. Crisp proposals were rejected due to the territorial ambition of Muslim League. Cabinet Mission Plan proposed a scheme accepted by the both parties. Meeting 9 December 1946. Muslim League boycotted. Constitution with the 2 bodies. Legislative body for the chaired G.V. Mavlankar, and to prepare a constitution for the free India, and constitution body chaired by the Rajendra Prasad to make the ordinary laws. So Constituent Assembly functions 20 November 1949. Its 11th session over the 2 year and 11 month and 18 days. Final session took place in the 24th January, and the continued to Provincial Parliament of India from 26 1950. Temporary President Sachidanand Sinha. Permanent was the Dr. Rajendra Prasad. Vice President H.C. Mukherjee. Constituent Advisor B.N. Rao. Temporary President Sachidanand Sinha. Permanent was Dr. Rajendra Prasad. Vice President H.C. Mukherjee, and the Constituent B.N. Rao. Next one is Composition of Constituent Assembly. Total strength 389, 296 British and 93 princely states. Seats were allotted proportional population. Election were conducted by proportional representation by means of single transferable vote. Representation of princely state were nominated by the respective head of the princes. Now there is decided upon seats decided principle of communities general, Muslim and Sikh. Committee of Constituent Assembly. Major committee was the Union Power Committee, Jawaharlal Nehru. Union Constitution Committee, Jawaharlal Nehru. State Committee, Jawaharlal Nehru. Drafting Committee, Ambedkar. Rule Procedure Committee, Dr. Rajendra Prasad. Steering Committee, Dr. Rajendra Prasad. Provincial Constitutional Committee, Sardar Patel. Advisory Committee for the Sardar Patel. Fundamental Rights Subcommittee, J.B. Kripalani. Minority Committee, S.C. Mukherjee. Committee on Functions, Constituent Assembly, G.V. Mavlankar. Order of the Business Committee, K.M. Munshi. And the House Committee, Patabi Sitaramaiah. Flag Committee, Rajendra Prasad. Finance Committee, Rajendra Prasad. Committee on Chief Commissioner was the Patabi Sitaramaiah. So this was some committees. Now Constitution was the Preamble 395-8, Article 22 Parts and 8 Schedule. Government of India Act was the Public Service Commission, Emergency and Office of Governor, Judiciary and the Federal Structure. Australian government concurrent list joint sitting of the party freedom of the trade. British Constituent Parliamentary form of government, bicameral system, cabinet system, legislation, single citizenship, rule of law, parliamentary privileges. Canadian is the federal form of residual power to the centre, advisory jurisdiction of the Supreme Court. French Constitution, republic, liberty, equality and the fraternity. Irish is the directive principal procedure or the presidential election and nomination of the system of Rajya Sabha. Japanese is the procedure established by law. Of South African Constitution, election procedure by Rajya Sabha and procedure by the amendment. Soviet Constitution, fundamental duty and the social, economic, political justice. And the US Constitution is the fundamental rights, independent judiciary, impeachment of the procedure of the presidents. US is fundamental right, independent judiciary, impeachment process, procedure removal of vice president, procedure removal of the Supreme Court judge, judicial review. Weimar is the separation of the fundamental right from DPSP, Germany. Next one is Preamble. Literally means preface of Constitution. So created based on the objective resolution Pandit Nehru. Preamble is non-justiciable, non-enforceable by any court. Element is Preamble cannot be altered under Article 368. As per Supreme Court, Preamble is a part of Constitution and 42 Constitutional Amendment Act 1976 added the 3 words of Preamble: secular, socialist and the integrity. Now next one is elements of Preamble. This is sovereign. India is the independent states and India is neither the dependent nor a domination of the nation. Socialist is added by 42 constitutional amendment. This follows the democratic socialism mean the production distribution are owned regulated by the India's own self. Mixed economy will be there. And India socialism is the blend of Marxism and Gandhian. Secular is added to 42 amendment. And no national region is country. All religion are same to support the states. Justice is 3 form of justice: social justice, which is no discrimination on the social basis; political justice, equal access to the political office and the equal voice; economic justice, equal opportunity to the economic goal. In short, to the fundamental rights, DPSP; equality, equal opportunity for all individual without discrimination; civil equality is for the fundamental rights; political is for the Article 325 and 326; economic for the DPSP. And this is the liberty for the thought, expression, belief, faith and worship. Liberty of thought, expression, belief, faith and worship. Ensure thought of fundamental right. Brotherhood, friendship of mutual support. Assured dignity of individual and the unity and integrity of the nation. Ensured the single citizenship, Article 1, Union of States and Article 51, fundamental duty. And democratic is the representation of parliamentary democracy, execution responsible to the legislation for all the political action. Feature of democracy, universal adult franchise, independent judiciary, rule of law and the periodic elections. Republic is the political sovereignty is vested in people. Head of the state is president and the president of India is elected indirectly. All public offices are open to the public without any class discrimination. Next, Article 1, India as the Bharat shall be union of states. States have no right to secede from the union. Classification of India as a territory of state, union territory, territory of the required India specified first schedule. Parliament can admit, establish a new law, new states. So this is Article 3, which is the uniting two or more states in the separation of territory from the state, uniting territory to a part of the state, increase the states, diminish the states, alter the boundary, alter the name of the states. Bill is sent to the concerned state to express view within the specified period. Opinion of the state not binding on the nature. President may accept or reject the opinion. Step 3 is bill is introduced in the parliament. After reconsideration of president, bill can be introduced at the house of parliament, and finally bill passed to the simple majority. So Article 2 is for the uniting two or more state separation of territory and uniting the territory or two or part. But the Article 3 is for the increase the area, diminish the area after the boundary of the states and alter the name of the states. Name is the JVP Committee, Dar Commission, Linguistic Province Commission 1948, Chairman is the Dar, and to find possibility to recognize the state on linguistic basis. So report recommended to recognize states based on ease of administration. JVP Committee is the Linguistic Province Committee, JVP 1948, to find the possibility in recognizing the linguistic basis. Jawaharlal Nehru, Vallabhbhai Patel, Pattabhi Sitaramaiah. This report is rejected. Fajr Ali Commission, this was the Fajr Ali, K.M. Panikar and the H.N. Kunjuru. This is the accepted the state formation on linguistic basis and suggested abolition of 4 part of classification A, B, C, D. Suggested creation of 16 states and 3 centrally administered territory. So this is Fajr Ali Commission. Fajr Ali, K.M. Panikar and Kunjuru was there. Accepted state formation linguistic basis, not of sole factor, but suggested the abolition of 4 part of classification. Now next one is Article 5. Every person domicile in India, territory of citizen of India, if born in territory, either his parents who are born in territory, ordinary residents of India by 5 years, and person migrated to the Pakistan to the territory of India are citizen of India. So be the either he is the parents or any grandparents was born in India or migrated before 19 July, an ordinary citizen from the migration and migrated 19 July registered as a citizen of India. A person is not a citizen of India if migrated to Pakistan after the first day of March 1947. Person ordinary resident in the country outside the India, citizen of India, if he has the registered in the citizen of India. Okay. Now a person is not a citizen of India if he voluntarily accepted the citizenship of any other country. Every person is citizen of India under the provision of any law made by Parliament, and Parliament has the power to make provision with respect to the acquisition and the termination and all other matters relating to the citizenship. Next one is Acquisition Citizenship 1955. Every person can acquire the citizenship if born in after 26 January, if born after 1 July, if born after commencement of Citizenship Act, and cannot require citizenship of the birth, parents, envoy, or the foreign diplomats. Citizenship is by naturalization. Citizenship person is not illegal migrant. Okay, and the person is satisfy qualification of naturalization after provision of the third schedule, and the person has the rendered distinguished service to the field of science, philosophy, art, and literature. So citizenship of incorporated territory is there. Territory is like a person has the outside India shall be citizen of India born after 26 January, but before 10 December 1992. If his father is citizen of India born after 10 December 1992, either his parents is citizen of India. And citizen by registration, if a person is Indian origin in the represent the any country of outside the undivided India, person is married to citizen of India and reside to the India 7 years. Person is minor children of person who is citizen of India. Person is full age in capacity who is the present registered citizen of India. A person is for certain citizen independent India and registers oversee the citizen of India year and residence of the 1 year. Next one is Article 1935 Citizenship by birth, by descent, by naturalization, by registration, by incorporation of territory, by citizenship, by termination, renunciation and deprivations. So minor is the foreigner without a valid passports, age of 18. So foreigner who remains beyond the permitted periods of time. Overseas citizens of India is the citizen Indian being a citizen specified country, and the ordinary residents of India is the India for the 1935 Government of India Act is given here. Next is termination of citizenship. Any citizen of India is of full of capacity renounce his Indian citizenship. Declaration has to be registered by the prescribed authority. Declaration of renunciation is withheld during his war engaging in India. So every minor child renounced person will also cease to be a citizen. Such a child can again become a citizen of India by declaration with 1 year after attaining. So it's a person voluntarily acquires citizenship of another country which cease to be a citizen. Central government may or by order deprive by a citizen of India citizenship. Registration of certification of naturalization was obtained by means of fraud. Citizen shown himself act as a speech of the disloyal, disaffected toward the unlawfully traded, engaged in any business, and the citizen sentenced 2 years in the country. Within 5 years of registration, citizens stay out of the India for a continuous period of 7 years. Next is the Part 3rd, Article 12 to 35 is initial 7 article, and 6th article is there. Article 31, right to property, has been removed, and 44 amendment it's add in a legal right. 12 is for the definition of state law inconsistent with of the derogation of in fundamental rights, right to equality 14 to 18, and freedom 19 to 22. 23 is the exploitation against, and 25 is the freedom of religion. 29-30 for the cultural education rights and right to constitutional remedy, then the power of the parliament to modify right to part 3rd, restriction to the right during the martial law, and legislation can give the provision of the part 3rd. Next is the characteristics of the fundamental right. Fundamental rights are not absolute right, they are qualified in nature. State can impose restriction as per the states. Fundamental rights are not permanent. It can be amended in constitutional amendment. Fundamental right can be suspended during the emergency. The fundamental rights are justifiable. People are moved the court to seize in violation and guaranteed by Supreme Court. Aggrieved person can approach to the Supreme Court directly. No need to appeal to a subordinate court. So fundamental rights are justifiable in nature, so anyone can go to the Supreme Court directly, not need to appeal the subordinate courts, and a right can be suspended during emergency, but fundamental rights are justifiable and state can impose restrictions and can be amended also. Article 12 is the government and Parliament of India, government and legislature, and all local authorities under the control of Government of India. Article 13 is like ordinance, order, bylaw, rules, regulation, notification, custom law. So law includes all of this. A written with written directions is order, authoritative orders, and the bylaws are regulation to the local authority. A rule or the directive made for the authority, and the law established under the law inconsistent with the part 3rd deemed to be void. Any law made by the state which takes away abridge the rights under the part 3rd. Article 14 is the state shall not be denied to the person capacity of before law. So state shall not deny the equal protection of the law. State shall not discriminate against the citizen on ground of religion, race, caste, sex and birth. No citizen shall on ground of religion, race, sex, caste registers and to access the shop, public restaurant, hotels, to veil and the tank, public bathing and the public resort maintain the state's funds. So this is special case. State is not prohibited to the making. So no citizen shall be on ground of religion discriminate on the empowerment. All citizens must have equal opportunity to employment to any office of under a state. Special case. State is not prohibit making special provision for the reservation promotion of this backward classes. State cannot be restrict to religious institution expanding their officials from this religion. Proper and practice untouchability in the forbidden, and untouchability is the office of punishable accounts of the law. State shall not confer any title, and the citizen of India shall not accept any title from the foreign state Foreign national holding office profit under the Indian government cannot accept presents and the monuments office of any kinds of from the under any foreign state without the consent of President. Foreign nations still holding office of profit under the Indian government can accept foreign titles only after the consent of the President. Article 14 is equality before law. State shall not deny any person equality before law. State shall not deny to the person equal protection of law. Article 15 is prohibition of discrimination. State shall not discriminate against the citizen ground on religion, race, caste, sex and birth. No citizen shall on ground with religion, race, caste is thus restricted to accept shop and the public restaurants, hotel, place of public and to use the well, tank and the bathing guards resort for the state fund. Special case state is not prohibited from the making special provision for the socially educationally backward, special provision for the women and children. So the citizen shall on ground of religion, race, sex, place of discrimination, all citizens have the opportunity to employments, and the special case state has no prohibition on the making provision for the reservation of promotions. State cannot restriction religion institution regarding to the election. Practice of untouchability in any form of forbidden. Untouchability in an office punishable in the accordance law. State shall not confer any title, and the citizen of India shall not accept any title. Foreign nations holding the office of profit under the Indian government cannot accept any presents, emoluments or any of kind of for under foreign state without consent of presidents. Foreign nations holding office of profit under the Indian government can accept foreign titles only after the consent of president. Article 19 is freedom of speech and expression, assembling, association, move to anywhere, D, and easily settle to anywhere, E, and the practice of profession is G. Okay, and move to anywhere is D. So this is the exception.